I will start. I just want to welcome everybody to the first part of Loyola Law School's three-part speaker series called Reimagining Justice, creating a new vision of policing, prosecution, and punishment. This program is being presented by Loyola's Project for the Innocent. I'm the legal director, and it's what we have is a nonprofit legal clinic that assists incarcerated individuals with claims of actual innocence. We really appreciate that you are attending the first part of our program, and we hope you'll join us for parts 2 and 3. Next Friday, September 25th, is part 2. We'll be talking about faulty forensics in the courtroom. The third part will be on October 2nd, Friday, which also happens to be National Wrongful Conviction Day. We'll be talking about wrongful convictions. And with that, we have some amazing speakers today. I'm gonna pass it off to our amazing staff attorney, Nikki Hurst-Cook, who put this program together for us. She's gonna talk about a couple of logistics before we get started. Thank you again for participating, and I hope you enjoy the program.
Thank you very much, Paula. Hi, everybody. I'm Nikki Hurst-Cook from Loyola Project for the Innocent, and I will be facilitating our Zoom panel today. We will have time at the end for audience questions, so please write your question in the Q&A field and we will get to them at the end. Now, please allow me to introduce our moderator, Professor Sean Kennedy. Professor Kennedy is the Executive Director of the Center for Juvenile Law and Policy at Loyola Law School, leading 4 clinics which address systematic injustices within the Los Angeles County juvenile court system. He has also taught at the law school for more than 15 years. Previously, Professor Kennedy was the federal public defender for the Central District of California from 2006 to 2014 and has served as chief of the Federal Public Defender Capital Habeas Unit. Thank you for being here, Professor Kennedy.
Thank you. We're going to have a hard-hitting, robust, and frank conversation about how to oppose mass incarceration, and not from a theoretical academic point, but from a real practical fighting in the trenches point of view. And to that end, we have an incredible panel, which is my honor to introduce you to and kick off as the moderator. So we have Keith Wattley here. Keith, nice to see you. Keith is the founder and executive director of Uncommon Law, which is a nonprofit that provides trauma-informed and client-centered holistic parole advocacy representation. Those of us who advocate for parole know him as a legendary advocate in this area. Before his nonprofit, Keith was a staff attorney with the Prison Law Office. And Keith, we really appreciate having you here today.
Really glad to be here. Thanks for having me.
And next we have Robin Steinberg, a senior fellow at UCLA Law and the founder and CEO of the famous Bail Project, which is really completely transforming pre-trial hearings and bail hearings across the nation. Robin is a former career public defender who has founded many impactful organizations in addition to the Bail Project, such as Bronx Defenders, which every public defender really admires and aspires to turn their organization into, Bronx Freedom Fund, and She Still Rises. Robin, thank you so much for being here to talk about the efforts to change bail in our state.
Thank you. It's a pleasure to be here.
And finally, we have Adnan Khan, the co-founder and executive director of Restore Justice. He founded this organization, which really is about rethinking how we look at people convicted of violent crimes. He founded this organization while he was serving a 25 to life sentence, and he was instrumental in passing felony murder law reforms in this state, SB 1437. And Adnan is someone who's representing many young people convicted under felony murder theories. It's just an honor to have you here.
Thank you for having me. Pleasure.
So why don't we kick off our panel by asking each of you to talk about both some of the successes that you have had in kind of attacking mass incarceration in your different areas. And also, I think importantly, the obstacles you see that prevent us from achieving decarceration and the release of more people from custody. And Keith, why don't we start off with you?
Well, thanks. I'm happy to kick it off here. This is one of the many times I'm really eager to hear from the other folks on the panel. So I'm here to learn as much as to share my own experiences. The folks that we work with at Uncommon Law are all serving life sentences. And as you can imagine, most of the parole commissioners we have that we're facing have backgrounds in law enforcement. They've spent their careers locking our folks up. And often the biggest obstacles is in having the commissioners understand our clients well enough to hear their stories. And that includes the stories of their families, their neighborhoods they grew up in. That includes their lives on the street, selling drugs, involved in gang activity, other things. It also includes their lives trying to survive within the confines of California's violent prisons. And I've found that, to tie that obstacle into the success, it's really that my clients' vulnerability is the key to helping commissioners understand them, particularly when they can honestly and openly discuss the fears in their families and their neighborhoods and on the streets and in prison. Through that process, they get to be rehumanized really for the first time after years or decades inside a prison that's really designed to dehumanize them in so many ways. And when they can make that connection, then a lot of other things are possible. The commissioners are able to see a future for our folks beyond prison, but it's a challenge.
Thank you. Robin?
Yeah, so, obviously the question, depends on how you define success, right? So when I think about the bail project, I think about the fact that we're working towards two different goals. The first one, to bail out as many people as we can, as quickly as we can, in as many places as we can. And the second one is really to work towards long-term systemic change, the elimination of cash bail, and the creation of a pretrial justice system where people accused of crimes can actually remain free to fight their cases. So I would say when I think about our successes and the obstacles we're facing, I'd say that with goal number one has been our focus since launching 3 years ago. We've already created 23 sites in 23 different locations. We've paid over 14,000 bails, over $31 million in bail money alone. We've hired local teams who lead the work in their own communities across the country. We've established a support team that provides whatever those teams need to work on the ground, from providing bail money from our National Revolving Bail Fund, to providing communication support, to doing data analysis to better understand how we're working and how to have more impact. We've also been able to create locally really robust partnerships in jurisdictions to ensure that clients get what they need when they get out, and that we can connect them to the social services that they may require or request, and that some of the basic needs that are going unmet are met. So that's, I think, some of the successes when I think about we're doing. I think the obstacles, because we're working towards long-term systemic change, right, are challenging, they're more nuanced, and I think that only a variety of strategies are really gonna work to effectuate real change. There isn't an easy solution to this problem, and it's gonna be made much more difficult by the fact that advocacy efforts are gonna have to be tailored to each individual state and each locality. And that's because at the state level, our criminal legal system is extraordinarily local, and solutions are going to have to be extraordinarily local and vary. And that is both a challenge and an exciting thing to engage in, but it's certainly a challenge. And also, and just finally, I think since cash bail is really a symptom of larger issues, the challenges and the obstacles that loom in front of us are large, right? We have to overcome our addiction to incarceration. We have to stop using the criminal legal system as a default to solve and address social problems that have resulted from generations of neglect and under-resourcing of low-income communities and communities of color, from poverty to mental health issues to family violence, to name just a few. And that's gonna require a real shift on how we approach these issues and think about it, to really shift our lens from you know, removing people in isolation and punishment to one of incorporating people into society and addressing people's needs and supports. And then, of course, finally, and embedded in our criminal legal system, from policing to the setting of cash bail to mass incarceration, the biggest obstacle that we're going to have to really face is the systemic racism that actually is evident in every single part of our criminal legal system, including cash bail. And that has to be dealt with if we're ever going to achieve any of our goals.
Thank you, Robin. Adnan, same question for you.
Thank you, Sean, and thank you, Robin and Keith. I'm already learning stuff within, 10 minutes, 5 minutes of starting this Zoom or this panel. It's hard really to define successes. I agree with Robin and Keith as well. Like, how do you define a success? I could have an individual success of my freedom, passing a law, or participating in it. But when I look at even the passage of 1437, the Senate Bill 1437, the felony murder rule, how it was amended, we still face challenges in that. Now, I've obviously had individual success and relief from the bill, but there are district attorneys who have challenged it for over almost 2 years now, or about 2 years now. Different judges, different counties, different people have different cases. It's been very challenging, actually, to have successes and to fulfill those successes. Furthermore, I think that one of the other challenges is that we are in a field or space of advocacy where results are very, very rare. And so it's fun and easy to celebrate the small results, but overall, there's so much more work to be done. So it's hard for me to answer that question directly by saying that what have been some of the successes, because there are a lot of my friends, personal friends, and a lot of our family and loved ones who have people inside, and just advocates who care about this system, unjust system. There's a lot more to be done. The other part of your question, as far as the work that we do within our organization, I believe that as mass incarceration became somewhat more popular and more people started to understand, or at least read about it or learn about it, a lot of the direction to undo mass incarceration in terms of prison and sentencing went to low-level non-violent drug offenses. And I think that that is very important and not to be neglected. However, I believe that all the focus has been shifted there. Now, it is slowly starting to shift at the wider scale of quote unquote violent offenses or people who have committed harm. And that is a very hard one. So we kind of have to start by reintroducing the concept of repairing harm. And we're talking about murder, like people who have taken a life of someone, homicide. And so how do we educate, reframe, and then restructure policies and repairing these damages done, not just from an individual, but systemically? I always like to share from my example, by the time I was 17, I was a parentless, homeless, high school dropout. The police showed up when I committed my crime. And so there are systemic reasons why people obviously commit crime, even homicide. So that has been one of the challenges of not saying that, hey, let's not talk about low-level nonviolent drug offenses, not saying that, or even innocence. When we look at movies or TV or shows, a lot of stuff is created around innocent people, which is absolutely crucial. But I think to isolate it only to where that is where the changes need to come from. And what happens is the distinction of who deserves mercy and second chances. I believe some people haven't even had first chances. What that does is it creates a distinction of who deserves what and why not. So that is where I would like to focus a lot, or where our work, kind of like Keith's work, is focused on, is reframing how we view violence and life/extreme sentences.
Adnan, as someone who represents at-risk teenagers convicted of homicide, your statements are just really appreciated. I have some particular questions for our panelists. I'm going to start out with bail, Robin. As someone who spent a quarter century as a public defender in federal court, which eliminated cash bail in the early 80s, my question is this: what does the alternative look like? Because in federal court, there's no There's no, money bail, but everyone seems to get detained. And so as someone I know who is a true advocate for decarceration, what's the plan to make sure we don't replicate what happened in federal court?
That's a really good question. And I think I'd like to start, if you don't mind, with sort of trying to connect cash bail and the work we're doing around reforming the cash bail system with where we are in this country in terms of racial injustice and the fight for justice, right, for communities, because I think they are connected. And I think it's a cautionary tale to see what happened in the federal system as we reimagine what our state systems might look like, right? So perhaps I think what's different about the murder of George Floyd is that it led to the uprisings that we're seeing across the country. And for the first time, people who don't live in the America that is over-policed and don't live in the America that is targeted by our criminal legal system, low-income communities of color specifically, they got to see in a visceral way the architecture of the system and the structures of systemic violence and racism that I think are embedded in every one of our systems. What became evident, right, is that a white police officer with his knee on the neck of a black man as he struggled to take his last breath thought he could do it without any accountability. And despite the other officers being present, despite the crowd gathering around and pleading for this man's life, he thought he could do it because it's what police have done for generations in this country. And something seems to have clicked. And it changed people. And many Americans saw for the very first time, I think, what structural racism and the violence that comes from it unfold before their eyes. Cash bail, whether it's in the federal system or the state system, like every other aspect of our criminal legal system, is a part of that system, right? In fact, I'd argue that it is the oil that keeps our machine running, because when you hold people in jail cells before conviction, before a government has had to put forth any evidence of guilt of any kind, people will do whatever they have to do to get home, because jail's horrifying, because it's traumatic, and because it's violent. And so people are going to plead guilty to get home, whether they did it or not, because it's the only way to get home to safety. And what that does, besides create lifelong obstacles because now somebody has a criminal conviction, is it also destroys the checks and balances that we think our system was designed to address, right? Because when you get 90% of people to plead guilty by holding them in bail bondage, what you're going to do is eliminate the possibility that our system, whether it's federal or state, has even the possibility of challenging police misconduct in courtrooms, challenge prosecutorial conduct or misconduct in charging decisions, or challenge why an arrest even happened in the first place or whether there's any evidence to sustain the charge. So cash bail, as we know it in the state system, creates a two-tier system of justice, right? One for those with resources and one with those without. And what we know is that if you can get out and fight your case from a position of freedom rather than desperation, you're going to have better life outcomes, you're going to have better case outcomes, your family and your community will remain intact and whole. So not only does cash bail make, so I think the question everybody wants to get to when we think about cash bail is people say, well, cash bail makes communities safer, right? And that really is the justification that some people think, well, we should have cash bail because it's going to make us all safe. And so when we think about reimagining a cash bail system, I think it's important to remember that cash bail doesn't make communities safer. The data is really clear that holding someone in jail pre-trial is going to make it 30% more likely that they're going to commit a crime when they get out than if they've been free. And when we talk about community safety, and I think this is really important, right? It's important to remember that the 2.5 million people held in jail cells annually in our 3,000 local jails across this country are part of community. They are part of public safety. So when we talk about public safety, we need to keep in mind that those folks being held in jail because of their poverty and race are part of our public too. So people worry a lot in reimagining a system about the theoretical risk to public safety, even though there is absolutely no evidence that eliminating cash bail is going to lead to increased crime rates. In fact, states that have eliminated cash bail, and there's not very many, have seen that violent crime rates actually continue to fall. The only evidence we actually do have, and what we should stay grounded in when we think about reimagining a system, is that when you hold people in jail, their safety is at risk every hour of every day that they're held in those jail cells. So the time is long overdue to dismantle the system like cash bail that we have and reimagine a new one that's grounded in freedom and dignity and equality. So some of the principles I think that need to be part of any new system are going to be that release should be the presumption regardless of charge. Pretrial detention should be the very, very rare limited exception. If government wants to take someone's freedom away before they've been convicted of anything, then they should bear the burden of proving that the accused is an actual risk to a specific person or community. And that has to happen not through the use of algorithms or risk assessment tools or other mechanisms like that, but that we should use our courtrooms for what they were designed to do, right? Which is to actually have courtrooms where we have open, transparent hearings where the accused is afforded counsel, can call witnesses on his or her behalf, can challenge the evidence being put forth, and that the government has to have a very high burden of proof that they must meet before taking away someone's liberty in a pretrial context, and where the decision-making by judges has to be not only transparent, it has to be in writing, and it has to be subject to appeal. So it, again, going back to what it should look like, right? It's going to have to really determine that holding somebody before conviction, right, should be the very rare limited exception. But in a reimagined universe, right, I think what you really want to see is divestment in our criminal legal system entirely as a way to solve our social problems, and investment in low-income communities of color that will guarantee people basic rights to food and housing and education and healthcare and the social services to address the underlying issues of mental health, addiction, and trauma. We're gonna have to shift our lens in recreating a system from risk to need, and accept our responsibility for the harm that our criminal legal system and incarceration has done for generations. But until we can do away with patrol cars and handcuffs and jail cells, whatever a pretrial justice system looks like in a reimagined world has to prioritize freedom, has to presume release regardless of charge, and has to allow that pretrial detention is only going to be used in the rarest and limited of circumstances.
Thank you, Robin. I think in the COVID era, your comments are particularly important. I do oversight of the sheriff, and the people in Men's Central Jail really are afraid of contracting COVID. And so that pressure that you talk about, it's just present when you walk in the jails. And I really appreciate your comments. I'm gonna move to Keith. Keith, Robin actually alluded to this. You are a master at parole representation. When I appear with clients before the parole board, I always, well, not always, but often am crestfallen because so many people who are just such great candidates for release are denied parole based on, they're found unsuitable because of considerations relating to their ongoing risks they pose to public safety. And I'm wondering, like, how you deal with that and how you look at that issue, because if it's just an algorithm, it seems like the full picture is not going to be taken into account. And from my perspective, there's so many people who could be released who are not because of this public safety exception. So I'm wondering, what do you think about our system? Is rehabilitation seriously considered? Is it really built into our system, or is it all punitive?
Well, I'll start saying I don't really believe in the word rehabilitation. I don't think it really tells us much about what happens or should happen inside prisons. Prisons certainly aren't designed for whatever people think of as rehabilitation. But the question about public safety, you're right that when parole commissioners deny someone parole, it's on the basis of some fairly vague and arbitrary sense that the person's release would somehow jeopardize public safety, create an unreasonable risk to public safety. And every parole commissioner kind of has their own sense of what that looks like or feels like. It's a very arbitrary process. But I think even if we have success on an individual level at parole hearings, there's a need, I think, to revisit this whole concept of safety. Anyway, I think safety is really rooted more in a different concept of health or well-being. If you look at the population of people in prison who are overwhelmingly Black, brown, and poor, and then you ask how many of them experience physical abuse, including sexual abuse, verbal abuse, emotional abuse, which they internalized believing that the abuse happened to them because there's something wrong with them, right? Inside the prisons, the rates of these kinds of abuses among people is it's as high as 70 or 80% among men. It's even higher among women, and highest among trans women. And I think so many people, while in the community, kids, people in gangs, people with substance addictions, people selling drugs, sex workers, others involved in other risky activity, they're suffering in some way and don't even know it, or don't know what to do about it. In other words, their lives are unsafe already. And they're unsafe because they're unhealthy. When they do ask for help, what do? We kick them out of school. We kick them out of the house. We put them in jail. We put them in prison. We put them on probation. So safety looks like healing from the effects of these unhealthy dynamics I just talked about. And if the goal of healing were to be the main driver of our system of justice, then the result wouldn't look anything like prison or jail or probation or parole. It would look more like restorative justice, which provides a way to make whole the person who was harmed and the person who caused the harm. It probably also looks like counseling, like therapy to actually address trauma. And our prisons provide none of those things. But we also, I think, have to realize that that all of this treatment of the trauma really treats the symptoms of the underlying issues of poverty and educational disparity and white supremacy and patriarchy, right? And I think so at a deeper level, safety really will come from creating real economic, educational, health opportunities for Black and brown and poor people. And until we're really having that conversation, we're not going to find public safety, certainly not within our prisons. And I think it's a much larger conversation, but not to be lost, I think.
Thank you, Keith. Boy, your comments are really spot on, and I appreciate you saying that. And it really segues into my question for Adnan. Like, there's so much advocacy and interest in decarceration right now, but often the debate is dominated by law enforcement unions, policy advocates, but as you pointed out, sometimes people draw lines. It's for drug offenders or nonviolent offenders. But there are many people convicted of violent offenses in the system. And I'm wondering, can they be a part of that conversation? Can we expand the decarceration conversation to dealing with, in my case, many people who committed a homicide as a very young person, have spent decades in prison and are amazing adults who could be released and make an impact on the world. And I think you're one of them. So how do we enlarge that conversation and bring in more people? And what does decarceration look like when it includes people convicted of violent offenses?
Well, when we look at decarceration is like reducing the prison population. That's how most people view it. So one thing we have to also consider is not to isolate or put bandages on problems. And so decarceration means many things. It means reentry. When you talked about, both you talked about public safety and what reentry may look like. Public safety is not just keeping society safe from people coming home. Public safety is rooted in what Keith talked about, is the safety of that individual. Because many times when people come out of prison, there's so many restrictions on them and stigmas on them that they're more afraid of society than society is of them, because society has never worked for people who've been incarcerated. They've been marginalized their entire lives, then during incarceration, and then upon release. So safety is providing safety for people who are coming out as we decarcerate. Now, going to your question about the distinction of who to let out. When we talk about mass incarceration and the volume of people that are in prison, 2.3 million people. I was reading a statistic from the Prison Policy Initiative that 10.6 million people go to jail every year. That's the jail churn. right? So going back to your concept of your ideas of Robin about bail, I mean, that's horrific. 10.6 million people of a jail churn once a year, but then approximately 600,000 people come out of prison every year. And so going back to the concept of who to let out, and we talk about mass incarceration, and as we rethink this whole thing, we have to also think about static incarceration. So as we look at the front door of prisons, we have to look at the locked back door as well, because that's where bodies are jam-packed. People are sentenced to life or extreme sentences and been there for decades and aren't going anywhere. When statistically, and if you just look at facts, literally the safest population who has the least recidivism rate are people who are convicted of homicide or life sentences. Another statistic I got from Prison Policy Initiative was in California alone in the past decade. So from January 2010 up until June of 2020, there have been 9,154 people released out of prison who were once convicted of life sentences. Now that's life with possibility of parole, that's life without parole, and that's even people who were sentenced to death, to condemned row. So again, as of June, and this number has increased as of June 2020. So 9,154 people who were once sentenced to life with, life without, or the death penalty are out here right now. But you don't hear about them. You don't hear about the fear of them. You don't see like, oh my gosh, this person who committed violence or once was serving life sentence, look at them creating all of this, havoc in the streets. But we don't want to address the statistics. We don't want to, we don't want to take that into account when we do talk about decarceration, because what we focus on is the crime. That is what we need to move away from. That's not to excuse what a person has done when they've committed harm. But when you solely focus on, I'm sure, Keith, this is the problem with the parole board. They say that you're not supposed to look at the crime, but when you do focus on just the crime, it is very, very difficult to move away from what a person deserves, whether it's to get out, to be decarcerated, to have proper reentry. That's one thing. Real quick, before I close off, I do want to touch upon what you talked about rehabilitation, and I wholeheartedly agree with Keith about, I don't believe in the concept of rehabilitation. One, I believe this is a misnomer, thinking that rehabilitation means here is this person who's a monster, who committed a harm, and they take a class, and they take the class to beat the monster out of them, and to beat the bad out of you. And that's how people generally view rehabilitation, as this is sole individual responsibility of the person to defeat the monster within them and prove to society why I am worthy, and prove to you that I don't have that monster in me anymore. But what I've learned, rehabilitation, that's not what it is. For me, finding healing and rehabilitation were two different things. And so finding healing for me was more about, yes, overcoming the struggles I went through as a child and the traumas that I carried throughout my entire teenage years into my prison sentence, into my life sentence. That's one thing. But as I found healing, rehabilitation, want to use that term, was truly me being reminded and really bringing out the best qualities in me that were never gone. They existed. Comfort, care, humor, charity. Those are things that were always part of me that never disappeared. Just because I committed a crime didn't mean that those were immediately absent from my life. Right? Maybe in that moment they may have been, empathy may have been lacking in that moment, definitely, but not in a totality of who I was as an 18-year-old teenager. And then what I really want to close off with is rehabilitation in prison. The classes that are offered in prison are helpful, can be helpful, but we have to look at the geography of the prison itself, not where it's located, but the economic and then the societal factors of the prison. So there's times where in order for me to find healing in a rehabilitative class, I would sit in a class, it'll be my day to share, which would mean I'm sharing my innermost pain, shame, trauma, abuse. And as I'm sharing this story, I'm visualizing either the abuser or those experiences as people are just listening. And then about an hour and a half later, the class ends and I go right into an environment where correctional officers are stripping me out, literally. get naked, let me search you, get against the wall, let me handcuff you. And there's no disrespect to military people who suffer from struggle with PTSD, but it's somewhat equivalent, at least how I equate it, is someone who is getting treatment for PTSD that as a veteran, and as soon as they come out of a classroom or that therapy session, they're back in the battlefield. So it's very counterproductive. So those who eventually go to parole board, it's a very filtered type of person who may eventually be found suitable. And so we don't factor in the environment and the system and what it's built on. What we do is just focus on the crime or focus on the individual and their sole responsibility to prove.
Wow.
Safety.
Wow, it's hard to even follow that. I really appreciate your comments about how we all play a part in this. We have a really important election coming up for the DA of LA County. And I feel like we're remiss if we didn't take advantage of your presence on this panel to ask each of you, what role does the district attorney in her office play in mass incarceration in our community? What do you think the district attorney, whoever that is, after the next election, should do to make things better? And then also, can we highlight anything the district attorney's office is doing right now that is working, that we should really recognize and keep pushing for them to keep doing that? Robin, you want to start us off?
Sure. I mean, the role of the prosecutor in mass incarceration, and particularly with respect to cash bail, couldn't be more front and center, right? Prosecutors get up every day in courtrooms across this land and they ask for cash bail, and they do it in almost every case without regard to the circumstances or the facts, right? So they drive cash bail, judges listen to their recommendations, even though I've always found it ironic because I think prosecutors are in the least well-situated position to actually determine who's a risk of flight or who might actually get out and create harm. But yet judges follow their recommendations. They continue to recommend cash bail. So they are front and center in, if you understand that cash bail is a driver of mass incarceration, which it is, they are front and center in being responsible for that piece of mass incarceration. When I think about what I want a prosecutor to do, whether it's here in LA or whether it's an election somewhere else, right, I think the first thing a prosecutor needs to do is bring to their office a vision that goes beyond the day in and day out operations of a prosecutor's office. I think they have to really understand and appreciate and be committed to addressing the systemic issues and the failures of our criminal legal system, and they need to connect to the communities that they're supposed to be serving. And they need to recognize that the criminal legal system and their role in it is connected to systemic racism and economic inequality, and they need to really think about the policies they set in relation to those larger struggles. Very concretely, I have a couple suggestions I would say to whoever the new DA is. The first thing you need to do, reject the use of algorithmic risk assessment tools in any context for setting cash bail, because they recreate and perpetuate and further embed racial disparities in setting cash bail and in the criminal legal system and in who gets held. So stop asking for cash bail. Judges are deeply influenced by you. Don't set it. They also have to be willing to take on police departments. And that means rejecting cases that are brought to them. And that means holding police accountable. And that means really doing an assessment about whether the arrest was constitutional, whether it was within the bounds of what we say about ourselves in terms of equal justice under the law. And that's a very, very hard thing, and it takes a lot of courage for a prosecutor to do, but they're going to have to hold police departments and police unions accountable and push back. They have to stop running on get tough on crime narratives. I can't stand it. It really makes my head want to explode. It really means that they need to reject the narrative of fear and stop trying to fearmonger to get people, right, to continue to over-police communities of color. So they have to really stop that. Instead, they should be running on platforms of justice, accountability, and community engagement. I think they should also create incentives in their own offices to reward those values, right? Instead of rewarding convictions and trial wins and guilty pleas, they really should create internal structures that reward and promote folks who really honor the values of justice and accountability and community engagement. And I think finally, and this is something that all of us, whether we're running a not-for-profit, whether we're in any organization in this country, but particularly DA's offices, I think that they need to ensure that the staff that inhabits the DA's office, that the staff that actually perpetuates its policies, that staff is diverse in every possible way, and that staff includes people with lived experience in the system and people who've been personally impacted by it. That until you have that in those internal voices that can rise up and challenge the policies you're creating, I think we run the risk of recreating the same problems over and over again. So I would encourage whoever the DA candidate is to ensure that they make sure their staff represents those voices.
Boy, Robin, if the DA just did 1/10 of the things that you recommend, I think we'd have a very different, for example, a very different narrative about why teenagers join gangs and what that means and what the punishment should be for youth with gang involvement. Keith, you're looking at the system from the other end of Robin. DAs show up at parole hearings all the time. What do you have to say?
Yeah, you're right. We're at the other end. We're 20 or 30 years sometimes down the road from where Robin's issues seem to come up. And when they show up at the parole hearing, just like they do on the front end, they pretend to be representing the people. When I think the people actually want real safety, as I was discussing earlier, not the illusion of safety. The people don't want to spend $80,000 a year to waste someone's life in prison, yet too often DA's representatives lack the imagination to see the person behind the crime and to recognize when it's time to release them. In most cases, at a parole hearing, the best we can expect from a DA in the best possible scenario that we can reasonably expect is that they show up and they take no official position on whether someone should be paroled. And that is very, very rare. We do have, there's a penal code section 1170D, which now allows DAs to petition the original sentencing court, even decades after someone's conviction, to bring the person back and consider whether they should be released. Very few DAs have used this so far. I think Chesa Boudin in San Francisco has probably submitted half of the petitions in the state. I don't know. But it's something that I think highlights the need for DAs to be willing to, again, see the person behind the crime and beyond the crime and consider that they have the capacity to change. I think it ties in part into conversation we were having earlier, and you were talking about this distinction between violent and nonviolent crime, and I agree with everything that Adnan had to say about this. But I think the language of labels matters for a lot of reasons, including one's dignity and their individuality. With so many different people just existing in the world, we go through life using labels to separate them into groups we care more about and those we care less about. If you think about labels we use like family, spouse, child, teacher, police officer, criminal, murderer, exoneree, prison guard, prosecutor, Republican, Democrat, some of these terms bring to mind people we feel closer to and others we're further away from, some we're afraid of. And another important thing about labels is that by imposing them on other people, we have the ability to really expand or contract the whole range of what's possible for that person, including the range of treatment or punishment we're willing to heap upon them. For example, a person in prison is a person first. And as a person, there are infinite possibilities for their thoughts, feelings, and potential. But an inmate can only be locked in somewhere. An offender can only offend people. So I think we need to encourage ourselves to allow people to define themselves, and we should all honor those definitions. I think that is a concept that really permeates this whole process.
Really great advice, Keith, for those of us representing clients. Really appreciate those comments. And then you're deeply involved in reform. Can you highlight what we should be doing to reform the system, whether it has to do with the district attorney or propositions out there that we could all take a look at in order to support decarceration?
Yeah, I mean, there's different things here. I can try to touch up on reform. I mean, that's a huge buzzword, and that's also a word that's been challenged in relation to abolition and what that means and all of that. So that could be another conversation. But I will add real quick about the district attorney. Is going back to what Keith was talking about why do we pick names and labels for people, and really not reconsider what those names truly are. So even when you look at a district attorney, an attorney is someone who represents someone. And apparently this is the person who represents a district, a location of a state or county. Now, as a person, as I committed a harm, but what makes society believe, or the legal system believe, that I'm no longer part of society? And so that the adversarial part of me versus them, or them versus me, is written all throughout law. When I get my motions or when I get my briefs about anything, it's the people versus Adnan Khan versus. And therefore there has to be a winner and a loser. I mean, you know, one on top of the other person. You can't have both. You can't have two winners in this adversarial system. And so, you know, when we rethink all of this, maybe we don't need district attorneys. All we need is defenders of public, right? And just one role versus the adversarial role. What we want is public safety. And not, you know, even when we use this language, we have very war language. Let's go out and fight. You know, let's defeat. Let's tear down. Is very adversarial language, even in advocacy. And so when we review language and words and roles and rethink everything, reimagine everything, we start to understand that what's been systemically set up does not provide not just safety for public, but for individuals. As far as like the term decarceration, again, like as I started, it's a big relation to getting people out. But getting people out does not solve or end mass incarceration. And even in the term of mass incarceration, the term incarceration is there. And so a lot of focus shifts to just prison. But as we all know, mass incarceration is a systemic problem. Dates back to the beginning of this country and how property, this country is built on the value of property, land, material wealth over human beings' lives. The native people, genocide. And so then that's where the idea of supremacy comes in, right? Where we're gonna keep the people in power, we're gonna keep and make policies that perpetuate us protecting our property versus people. And then you look at the slavery and enslaved people in terms of property and use of labor to perpetuate, you know, capitalism, if that's what you want to call it, which it is. And then systemically, after, you know, 13th Amendment, again, a lot of us view the 13th Amendment as slavery has been abolished, but in the very same sentence, it says slavery is legal. And I think that's how we should definitely acknowledge and celebrate the freedom of the traditional concept of slavery, of enslaving people in plantations. But like I said, in the very same sentence, it actually says slavery is legal for those who are duly convicted. And then as soon as Civil War happened and Reconstruction, we see laws immediately being created to incarcerate people, specifically Black people, and get sent to camps, you know, labor camps, or back into the same plantation. So here we are in 2020, as we talk about decarceration, not to isolate that from mass incarceration, which is also systemic, which roots back to what are the services that are provided for children, for communities, for education. Are we paying teachers, their mental health services? I mean, all the stuff has been more popular now than it was 6-7 months ago. So as we look at decarceration, if we talk about just releasing people, that's one thing, through commutations by a mercy of a governor, through parole representation like Keith is doing, to let people out through passages of Senate Bill 1437 or different legislations that have allowed people to either appear before the parole board sooner or just come home. That's decarceration. But what about when they come home? So re-entry, decarceration, all of it is one thing. We need to look at it as one whole connected thread versus an isolated incident. Then what we do is just put these small bandages on people when we really need surgery on the entire system.
Really, really great comments. You know, every year I practice, I see the importance of reentry more and more. Can we take a few questions from our audience? We have 170 people out there following us. Panelists, are you up for it? Okay, Nikki?
Yes, I'll read the first question. Are you encouraged by any of the reforms you've seen concerning the treatment of juvenile offenders, or do we still have a long way to go?
I'll take it as it relates to people who were convicted in their youth and given life sentences or really long determinate sentences. We had a series of laws dating back the last few years that allow them to get a special type of parole consideration hearing where their youth and limited brain development, et cetera, are supposed to be given special consideration. In fact, given great weight is the terminology. And the parole board is supposed to, I mean, there's supposed to be a stronger presumption in favor of granting them parole because of their capacity to change. So that's been great. A lot of people, thousands of people have become eligible for parole consideration under these new laws. Unfortunately, the system through which they are being considered for parole is the same. And even though the rules say give them great weight, the practice is that most of them are denied parole when they go to the parole board, just like those who were over age 25 when they committed a crime. So I think we have to fundamentally change the subjective nature of the parole decision-making process. Both the decision makers and the process itself need to be changed so that there's a better chance, a better opportunity, a more meaningful opportunity for people to actually be released, regardless of how old they were when they were convicted. I think that on its face, the law is good, and in practice, it does give a lot of people a chance to go to the parole board, and in turn gives them hope that they didn't have before. But too often, those hopes are dashed when they get to the parole board that fails to see the person behind the crime.
Adnan, you want to add anything?
Yeah, can you ask the question again, Nikki? I'm sorry, specifically about the juvenile, and is it in relation to parole board only?
The question was, are you encouraged by any of the reforms you've seen concerning the treatment of juvenile offenders, or do we still have a long way to go?
Well, I'll start with the term offender. Like Keith was saying, language, I think we're talking about, even juvenile has a label to it. So juvenile offender, coupling those two terms together has a very negative connotation. So we're talking about children, right? We're talking about children who have committed harm, and then understanding why they've committed harm. So have I seen, when I was when I was incarcerated and Senate Bill 260 in California came about and was passed, and what that was anyone who was 17 and under and had sentence of more than 25 years to life was able to go to the parole board at 25 years. So I had a friend, for example, he was sentenced to 45 years to life at the age of 15. And when that law passed, he was on his 23rd year, he was able to go to the parole board since he was 15. And yes, he was found suitable and he went home. And so that provided relief. But what we're still saying is that you still need 25 years as a 15-year-old who has committed murder. And that's not taken away from the child's accountability, but it's saying that sending you to an adult prison on your 18th birthday, was that the solution? And then about 20 some years later, for you to sit in front of people with two law enforcement backgrounds to, determine whether you're safe for society or not. And then on top of that, he was sent to maximum security prisons as an 18-year-old on his birthday. Like, that's very violent of a state to do that. So have I seen legislation? I've seen, Senate Bill 260 turn into Senate Bill 261 that increased the age from 17 to 23, I believe it was, and then another bill, 1308, passed, which increased the age to 25. Same concept of the law, just increased the age. And so those were very positive. A lot of my friends came home under those legislations, so it's been great. But I think that not to be settled there, because the larger scope of it is still inhumane, in my opinion, to send a child to prison for 25 to life. There's still people in prison who've been there. I have a friend, he has 26 years in, been incarcerated since he was 15, still there. And so I think that we should definitely celebrate and be proud of the people who are out and people who have passed these pieces of legislation. But I like to celebrate small and quick and then move forward.
Yeah, we have a long way to go. There's been incredible reform coming out of the U.S. Supreme Court, the California Supreme Court, Sacramento. We have a long way to go in LA County, the district attorney, the trial court, the juvenile courts, even the intermediate appellate courts. But we got to keep fighting, because progress is on its way. You got another question, Nikki?
I was actually going to ask Sean if you had any ideas or recommendations for what could be changed with regard to juveniles, since you work in the system as well.
Yes, I mean, I think we're already seeing we have to stop criminalizing youth. We have to acknowledge that children are different, and children means teenagers. And one of the biggest thing is, I think gang exceptionalism has ravaged our youth, labeling people a gang member, giving them gang enhancements, and penalizing them mightily, and carving out exceptions for them because of alleged gang membership is the wrong way to go. But the progress has been enormous, and if we keep pushing at the local level, there's been lots of comments about that, I think we'll see real reform.
Can I jump in, add one thing about some of the things that I have seen around youth that actually was contributed to the passing of those laws that I talked about? It was the addition of science into the explaining and understanding to legislators about the brain development of children. And I'm not a scientist, so I'm going to try here. Please, someone jump in and correct me or explain better than I can here. But from what I understand is that the concept of the brain developing fully at the age of 25. So as the brain develops, it develops from the back to front. The front part, our prefrontal cortex, is the decision-making part of our brains. So as children, as our brain develops, we're actually, as you know, teenagers are more emotional and impulsive than thoughtful. And that's by brain design. That's just our physical human beings, how we evolve. And so as children, I know for a fact that I've done things in groups for acknowledgement and also to express my impulsive emotion that I had. That emotion, impulsive emotion, comes with being abandoned, neglected, abused, thrown out. Drugs are a part of that as well. And so not excusing the harm that's been done, but those pieces of legislation that I...
Sorry, Adnan, you're cutting out. Nikki, it's...
Am I back?
You're back.
Sorry.
Wrap up.
I'm just going to close out by saying that the brain development is that children make decisions based more on emotions than intellect.
Amen to that. Nikki, it's 12:02. I feel like we could go another hour, but I promised you I would keep a schedule. So I just want to thank this incredible panel. It's just amazing to hear you all talk together, and it really creates a narrative of decarceration and fighting mass incarceration that inspires me and the many people on this Zoom call. I want to say we need to take a 15-minute break, but promptly at 12:15, we're going to have an incredible conversation between the progressive DA Larry Krasner and Geneviéve Jones-Wright. And I hope that you will join us, take a break, get some coffee, check your emails, and then rejoin us at 12:15 for that conversation. And I also would be remiss if I didn't say, please vote this next election cycle. There's a lot of important issues on the ballot. Robin, Keith, Adnan, it's just been an honor to be here with you and hear your views. And I hope that your views win, because you most definitely have the way to create a better, more effective criminal justice system than what we've got right now.
Thank you.
Bye, everyone.
Thank you, everybody,
Bye.
for joining us.
Delighted.
Really appreciate it. If you are, I don't know if the two of you have met before.
Oh, yes. Geneviéve and I we're old pals.
Great.
Nikki, let me know if you want me to start broadcasting.
Yeah, so if we're ready, DA Krasner, let me know if you're ready and we will take this live.
We're
And I
all
will
ready.
introduce-
Let's go.
Okay.
Thank you.
Thank you all for joining us. We're going to get started. I'm again Nikki Hurst-Cook from Loyola Project for the Innocent, and I will be facilitating this Zoom panel. We will have time at the end for audience questions, so please write your questions into the Q&A field. We are honored today to be joined by Larry Krasner and Geneviéve Jones-Wright. Geneviéve Jones-Wright was raised by her single mother in a low-income home in San Diego, California, where devotion to family and self-respect were cultivated. In the 4th grade, Geneviéve decided to follow in the steps of Justice Thurgood Marshall and has been deeply devoted to social justice work ever since. She earned a BA in Mass Media Communications from the University of San Francisco and obtained a JD from Howard Law and an LLM in trial advocacy. She served San Diego County as a public defender from 2006 to 2019 and now serves as the founding executive director of Community Advocates for Just and Moral Governance, an impact litigation organization in San Diego. In 2018, Ms. Jones-Wright ran as a candidate for District Attorney of San Diego County. Her candidacy had been described as part of a reformist wave in DA elections across the United States. Geneviéve serves on the board of directors for the David's Harp Foundation, is vice president of the Earl Gillum Bar Association, and a volunteer attorney for the California Innocence Project. Thank you for being here with us, Ms. Jones-Wright.
Thank you for having me.
Larry Krasner is the Philadelphia District Attorney. He was elected in 2017 and began his term in January 2018. Mr. Krasner received his undergraduate degree at the University of Chicago and his JD at Stanford Law School. He worked as a public defender in Philadelphia and then went on to the Federal Public Defender's Office until opening his own law firm in 1993, where he specialized in criminal defense and civil rights work. As a defense attorney for 30 years, Mr. Krasner tried thousands of cases in criminal and civil court, represented countless defendants, and filed more than 75 civil rights lawsuits against the police for corruption and physical abuse. Mr. Krasner ran for Philadelphia District Attorney in 2017, stating that his top priority would be ending mass incarceration in Philadelphia. Throughout his 30-year career, Mr. Krasner has also proudly demonstrated a steadfast commitment to social justice, having defended protesters pro bono who are involved with movements including ACT UP, Black Lives Matter, DACA Dreamers, Anti-Poverty and Homeless Advocates, Occupy Philly, and among many, many others. I want to thank you both for being with us today. And with that, I turn it over to Ms. Jones-Wright.
Thank you. First and foremost, I just want to say thank you so much for having me be a part of this very important conversation with Larry Krasner, a man who I respect immensely and a person who provided lots of support to me as I ran as a progressive district attorney here in California. So it is my honor to be here speaking with Mr. Krasner about the wonderful work that he is doing in Philadelphia as the district attorney. The district attorney, as we all know, is one of the most powerful positions in our criminal justice system. And thankfully, we have begun the conversation around the power of the district attorney. Prosecutors are very powerful actors in our criminal justice system. We know that they have very far-reaching discretionary powers. They determine who is going to be charged with what, when, how they're going to be charged. They make decisions as to bail recommendations, what witnesses are going to be called, and of course, they control plea bargaining. In recent years, there's been a movement of what has been called progressive prosecutors running to be district attorneys all around this country. And often, many of these candidates, like myself, come from outside of the district attorney's office. these progressive prosecutors have sought to address issues from mass incarceration to reducing racial disparities in the system. And these prosecutors, or potential and hopeful progressive prosecutors, have had successes in just bringing the conversation again to light. We cannot minimize that. But then also when they get into office, they install and implement many policy changes and programs, but they often face challenges both while running and while in office. So my first question for you, Mr. Krasner, is what does it mean to you to be a progressive prosecutor? And why do you think that there has been a movement for more progressive prosecutors?
So you are going to call me Larry, right? That is what we're going to do here, right?
I will do that, sir.
All right. All right. So Ms. Jones-Wright, Geneviéve, and I have actually known each other for a few years. And it's great to have a chance to speak to you again. If I could have voted for you from Philly, I would have. And you and I will be having conversations in the future, I'm sure. I would love to see you have that kind of discretion that you're talking about. Although I think the work you're doing now is at least as important. I think it's incredibly important. So why is it important to be a progressive prosecutor? Because they have the power. And because the people who have the power can do a lot of harm or a lot of good with it, I figure we should do a lot of good. So the reality is that if you are a US Senator and you want to get something done, you're going to have to log roll with a lot of other US Senators. And maybe, if they get their pork belly project and you get your little project, maybe you can actually do something good together. If you're a DA, you just make the decision. Somebody thinks you should be executing a person or seeking that execution, you say yes or no. Somebody thinks that you should drop a case or fully prosecute a person, you say yes or no. Somebody thinks you should divert a particular type of a case, use a misdemeanor, use a felony, seek a long sentence, seek a short sentence. That's up to you. You have that power and the ability to do it. The problem we have had in our system is that the government was fine with having a ton of discretion when the people exercising the discretion were locking up more and more people, giving them longer and longer sentences, and getting us into the politically helpful but nationally disastrous situation we have now, which is as the most incarcerated country in the world, where we have taken all of these resources out of things that prevent crime and make us safer for the purpose of, basically politicians improving their careers during a period when talking tough got you to higher office. So it's a really important spot. I actually think there may be no more consequential, powerful spot in terms of the ability to make unilateral decisions in life and death matters than to be a chief prosecutor.
Absolutely. I would agree with that. I have a bit of a personal story. When I was still a public defender here in San Diego, I was actually summoned over to the district attorney's office by a now chief who was a head of a unit. Basically, he tried to recruit me to come over to the district attorney's office. And I said, well, I will never be a DA. And so back in 2018, he saw me at one of my campaign events and he said, you told me you would never be a DA. I said, exactly. I will never be a DA, but I will be the DA. And so when we talk about this discretion, this extraordinary power that DAs have, we really do have to talk about the culture in the office, because I think that for a lot of law students who really plan to do very good things as prosecutors, they don't understand that coming in as rank and file, if you don't have a person like yourself, who is the district attorney, who is heading up that office, who's implementing policies, who's setting the tone there, that they're going to have to just kind of go along with the marching orders. And so we've seen where the culture of the district attorney's office has been changing under leadership like yours. Could you please talk to how the culture changed when you became the district attorney in Philadelphia?
Sure. So, it is one of the greatest challenges we have. You're not just fighting against the sort of self-serving political prosecutorial culture that if you are a hard-nosed prosecutor then you can become the mayor, and then you can become the governor, which is reality. I mean, the reality is that district attorneys or chief prosecutors have very often been people who are politically on their way up, and they use the office far too often to get to higher office. That often meant really just worrying about the press, as opposed to worrying about justice at a time when the press was very, very pro-carceral. How do you change a culture? Well, it's that, but I mean, let's be honest. You're dealing with a culture in the United States that is the foundation of all of that. That culture within the United States goes back centuries in terms of being extremely discriminatory and founded in slavery. I mean, let's get real. That's what it is. So you're not just fighting the culture within the DA's office, you're fighting the culture within the judiciary and within the other institutions of criminal justice, police departments, but you are also fighting a much broader culture which underlies the culture of the whole country. Thank goodness some of that is changing, which is the only reason why somebody like me or Kim Fox in Chicago or Marilyn Mosby in Baltimore, Rachel Rollins in Boston, or George Gascon, who is running now in Los Angeles and whom I know and who I sincerely hope is going to be successful. It's the only reason any of us are in office, and there are more and more of us who are in office across the country. More and more big cities are ending up with progressive prosecutors. So there is a grassroots popular movement that is voting for the ideas being expressed by progressive prosecutors. And when voters start to tell the people they elect what they want, you're off to a good start. But you're still going to get to an administration where you have generations of people who have been selected to be pro-carceral, who have been selected in a way that carries out all of the worst impulses. They've been trained, they've been elevated, they've been kept or driven out, they've been made into supervisors according to this old philosophy. And you're going to have to fight it. When I first got there, I fired a small number of people. I've been sued over all that. In fact, I did a 14.5-hour day of depositions 2 days ago because they all claimed it was age discrimination, even though most of them are younger than me. Go figure. But you know, you're going to face that. You're going to have to be willing to say that there are some people who, no matter what I do, will undermine the mission, will not embrace this mission. So I may have to separate some people. You may have to move people around in the office. So if all they're going to do is undercut your mission, you may have to put them in a place in the office where they can do good work, but without influencing other people in the office. You're going to have to educate. Education, science, data, and evidence-based approach to criminal justice is not the tradition. So we started to have almost weekly sessions of an hour or a couple hours where we would educate the entire staff, because the truth is the vast majority of them, even if they come from a different philosophy or have different politics, they really do just want to do a good job at their job. And if you tell them north is over there, not over there, they might actually go north, right? So you have to do that as well. You got to change your evaluation forms. One of the really interesting things we found was the evaluation form that used to be here never said, did this prosecutor ever come to you and say, I think this person might be innocent? Did this prosecutor ever come to you, supervisor, and say, I think this is an illegal search? They didn't value that. What they really just wanted to know is, did you work hard and did you get wins? There was no real interest in justice. It was more of a scorecard, almost like a sports event. So you have to start to look at all of that, and then you have to take very seriously recruiting. And I say that as someone who came into an office where our diversity was, among attorneys, was only 20%. It was 80% white, and I happen to be white. I like me some white people. That's not my point. But my point is that it was white for a reason. And the reason was that a lot of the people running the show only wanted to go to the schools they came from, which were not very diverse. They were homers. They only wanted to stay in Philly. There is a different way. And we started it immediately, which was to go to almost 30 schools around the country, all kinds of states, locations where we had never gone before. Absolutely fabulous schools. But we also went to all 6 historically Black college and university schools. And so our new entering classes, which are large classes of attorneys, one of our classes was 65. We just started a class of 47. These are classes that are nearly 50% diverse, 50%. And we are in a city that is 60% diverse and 40% white, right? So little by little, we are getting closer to having an office that has ideas from everywhere, personalities from everywhere, accents from everywhere, that is also diverse in terms of religion, race, ethnicity, almost everything else you can imagine. And that also has an influence. That's different than having nothing but local people who are third, fourth generation local people whose parents were court officers and police officers and firefighters. We need them too. We have plenty of them, but we need to round it out. These are some of the ways that you get a culture change. And then of course you got to come with some serious policies and you have to enforce them. That is a whole discussion all by itself. Because the truth is that the culture in your office is going to try to kill your policies. The people who can on a daily basis, our office is 630 people. On a daily basis, the middle management can shut you down. So you have to watch that. You have to be careful about it. And then you can get somewhere.
Absolutely. Well, Larry, you have said so much, and I kind of want to delve into some of the nuggets that you talked about. You said that it's not just the culture of the DA's office, but it's also running against the culture of the United States. We so often hear that our criminal justice system is broken. Now, I'm a co-founder of MOGO, which is an impact litigation organization that initiates lawsuits in order to facilitate change in our systems, because we recognize that all American systems are rooted in racism. And for me, when I hear that our criminal justice system is broken, I always like to push back, especially as an adjunct professor in a criminal justice program. We usually hear people cite to the over-policing or the disparities in prosecutions of certain communities, mostly obviously communities of color, and how certain community members serve extraordinarily longer sentences than their white counterparts. But understanding what you said, that deeply embedded in our country is this racism that is rooted very, very deeply in all of our systems. What do you say to folks that say that our criminal justice system is obviously broken?
Well, in my mind, there's no question that it is. It was not a lifelong dream of mine to run for office or to run for DA. It was something I did after 30 years in courtrooms where I got to spend more time watching than doing, but I did a ton. And you saw what was going on. I think in some ways, Ta-Nehisi Coates has said this best, and he says a lot of real good things. But one of the things he talks about is, I forget the phrase exactly, but he's speaking of gun violence and the killing of African-American people in their communities. And he talks about how before there was this chalk line around the body, there was a red line around the neighborhood, meaning, speaking of course of deliberately discriminatory practices, not only in terms of housing, but most importantly in terms of banking, which at every level have caused these terrible problems. The criminal justice system is built on all kinds of other bad stuff, discriminatory policing. It's built on defining certain kinds of offenses that are not offenses wealthy white people commit as being the dangerous ones. It is built on all sorts of things we almost take for granted. I mean, if you start thinking about the consequences, even if we are fair right now, all of a sudden, we all got a mind erasure and we became completely fair, you're still operating in a system where we sentence people according to what prior records are. And we know that we have a system that has enforced at 5 or 10 times the level in a poor Black community as it does in a wealthy white community, right? So even when you try to build a house, the foundation is already crooked. And of course it goes back farther and farther because yes, racism is, one of the giant cracks in the foundation of criminal justice, but so is wealth. And there are other ones. There are so many of these things that are discriminatory and really undermine something fair, that you have to be very proactive when you are inside the system, whether as a judge or even as a legislator, but I think especially as a chief prosecutor, because you have so much power. You have to be very proactive to try to rectify some of these things.
Indeed. And one of the things that I love that you talk about is how district attorneys have an obligation to end mass incarceration. So in your work, trying to do just that, I'm pretty sure you are facing many, many obstacles. I've read articles. You're not just getting it from well, you're getting it from all sides, but you're even getting it from the U.S. Attorney, for instance. But I want to talk a little bit about the obstacles you face in your work as a district attorney in Philadelphia, even from judges, many of whom are former prosecutors themselves. And what happens when you and your attorneys receive backlash from judges who are resistant to change? How do you work around these obstacles, and what strategies have you found to be effective?
Sure. So there is good news and bad news in that regard. Philly is very interesting in terms of its judiciary. The judiciary is it is a slightly over 50% African American, and it is slightly more women than men, which might not be what you expect, and certainly is not what you'll find in the outlying counties. But it is here. This is also a city that's about 80% Democratic. So what you're dealing with is a whole lot of Democrats. That's not a bad start, honestly. But government being what it is and culture being what it is, it's more complicated than that. My wife was actually a judge for 19 years in the highest trial court in the system in Philly. So I knew a lot of these judges in that capacity. She just retired to run her own mediation company. But what you actually see is an early moment when an awful lot of them are disturbed because it feels uncertain. You know, I do think it's a fair statement that a lot of judges are drawn to the certainty of decision-making and finality and predictability. And so when things are new and you're starting to say things like, I want my prosecutors to tell a judge how much it costs to put somebody in jail for the period of time they are requesting. Some of them got very upset about that. It was new. I mean, if you think about it, so what? We talk about what everything else costs, but it caused a big commotion. The press has a symbiotic relationship, unfortunately, with what goes on in the court system. And so if you have 100+ judges, which we do in Philly, and you have 2 of them who are vocal and critical, the press is going to cover those 2, even if the other 98% are going with you. I think it is fair to say that in the last 3 years, we have gone through an earlier period of more resistance. The resistance has decreased over time, but we always have a couple of detractors who get a little more publicity than you might expect. When we try, this is something Dan Satterberg actually shared with me. He is the district attorney in Seattle and has been there for a very long time, both in the office in more traditional times, but as a progressive himself. Republican, by the way. But one of the things he said is, look, when the DA tries to do something on their own, when they have the power to do it themselves, everything goes smoothly. As soon as you try to get the police to do something with you or the judiciary to do something with you, that's where everything gets bogged down. So to a large extent, we have found that the way to try to bring change within the judiciary is to figure out, first of all, what can you do on your own? And try to do that. And then when you have no choice but to get them to be on board with you, then you try to work with them. And we've had, just as he did, we've had much less success with that. I will say this, we have a very different philosophy about sentencing, for example. Philadelphia is the worst city in the United States for excessive supervision, by which I mean parole and probation periods. Not uncommon in Philly to have 3 months in jail, followed by 20 months of parole, and followed by 24 months on a subsequent probation. That's a 15-to-1 ratio. 3 months in, almost 45 months out of supervision. We have been trying to change that, and the judiciary doesn't want to change it. They don't want to do anything that is retroactive. They don't want to reduce the huge patronage pit that is our enormous probation department here, because never forget, politics is around the corner, right? But what we have done is internally, we set a policy not to seek long periods of supervision. And when we go to judges with a negotiated guilty plea of some sort that contains far less supervision than before, almost all of them are okay with it. Why? Because it resolves the case. Because the only alternative they really have is to say, I refuse to accept this guilty plea unless you do A, B, and C. And most of them are just not willing to do that. They got a long list, they got a lot of cases, they got other things to do. They're willing to do that. So, in that sense, we have seen, and it requires the judiciary to buy in, we've seen about a 2/3 to 3/4 reduction in the number of future years of supervision that are being generated by the court system. I mean, that is pretty amazing. We've also seen something like a 50% reduction in the future years of incarceration. that the court system was generating before the pandemic. Well, everything got scrambled with the pandemic because the courts closed. But if you actually look at what we were able to get done in those couple years, it's pretty amazing. And that really is the key to ending mass incarceration. It's not what's going to happen the day after you are in office. It's what's going to happen when the last administration's 5-year sentence turns into a 2-year sentence. The last administration's 2-year sentence turns into some kind of a house arrest. Some of these cases turn into diversions. You will see that impact in 2 years and 4 years and 5 years, and it will be a tremendous impact. And we have been very, very successful in getting that. But yes, of course, there are judges who cannot stop dogging us and saying terrible things about us and calling us names in court and saying we're doing everything under the sun. That's how it's going to be. I've made a point of trying not to return fire, partly because my wife was a judge, and I think it's kind of unfair for a prosecutor with all their power and their platform to take shots at judges who are ethically prohibited from responding. In Pennsylvania, I don't know how it is in California. So even when we're taking punches from a few of the more strident ones, we try not to call them out individually so that we're not, so it doesn't appear that we're at war with them. And I would say generally, you know, about 98% of what we want to do, including exonerations, including shorter sentences, dropping cases, not pursuing the death penalty, about which we, you know, have done in many specific instances. About 98% of the time, we do exactly what we want to do. And then we still face the 2% of the time when they're going to yell and scream and carry on. It's going to be in the paper. And for me, honestly, that's okay too, because it kind of lets the public know that there are challenges within the system and that things are changing.
So Larry, you mentioned exonerations. I do want to talk to you about some of your reform successes, especially ones that center around the creation of your CRU that has exonerated numerous people. There was a recent article in the Philadelphia Inquirer, came out just about 3 days ago, and the headline read something like this: Philly's wrongful convictions have frequently involved official misconduct. There's tales of detectives coercing false confessions from suspects, and prosecutors illegally withholding evidence from defendants, and police officers doing shoddy work or secret investigations of alternative theories and burying records in the case file. So we know that this is clearly not just a quote unquote Philly problem. This is a national problem. This is why we have Loyola Project for the Innocent at Loyola Law School and the California Innocence Project, of which I'm a volunteer attorney. So your office has helped to overturn at least 14 homicide convictions in the last 2.5 years, according to that article. And official misconduct has been cited in a lot of those cases. Can you please talk to us a little bit about what led you to create the CRU? I've heard comments from Patricia Cummings, who I'd be remiss if I did not say to the attendees today. She will be speaking in depth about the CRU unit in your office on the third day of this event. Patricia, of course, is the head of that unit in your office, but she said something that really struck me. She said that she believes the issues leading to wrongful convictions are more pronounced in Philadelphia than elsewhere, and that 12 of the 14 exonerations that she has presided over have involved official misconduct. So I'm wondering, when she relayed this to you, did this surprise you? Did you know that the problem was so deeply steeped in bad behavior and law breaking by those charged with seeking justice? I mean, we all know that wrongful convictions happen, but did you know all of this before you actually started the CRU?
Yes, I absolutely knew that the culture of the DA's office was a win at all costs culture. 30 years into my career, I had tried death penalty cases and more than one, and I had tried a lot of homicide cases. Those cases typically are ones where there's a lot of pressure and there's a lot of politics. And often they involve some of the hardest driving prosecutors who are pressured either by their own ambitions or by the chief prosecutor, who's very political, to win to some extent at all costs. And I had seen that kind of culture in the office over and over because I really was in court doing criminal cases 45 days a week for 30 years. So that did not surprise me. it was also coupled with another thing that I didn't understand as well until Patricia Cummings came here to do our conviction integrity unit. But that is that Philly was backward when it came to forensics. We were not preserving and doing DNA in as vigorous a way as we might have. There were many, many years of no videotaping of confessions, no videotaping of witnesses, the tricks, the brutality that were going on in the room, the lies, which by the way are legal, but still pretty despicable, that were being used to get people to confess, including promising them that if they would just sign this paper where the text had been covered by someone's hand, then they'd be allowed to leave. Those kinds of things were endemic. They went on all the time. Some of it was, in my opinion, related to the crack wars and the war on crack, I guess is what I should say, and the incredibly high number of homicides that occurred in that era when you were looking at 550, 600 homicides in Philly. And we're having a terrible this year, but in recent times it's been half of that or less than half than that. When you give power to the wrong kinds of people, this is what you get. We are proud of the fact that we have these 14 exonerations, but make no mistake, there are a lot more people who should be exonerated. If you look at what Kim Foxx has done in Chicago, she got to her office before mine. I'm a big fan of Kim Foxx. It's a larger jurisdiction. They have exonerated something on the order of 100 to 150 people. And I know that because I was with her for a couple of reasons, but I remember being with her at a gathering of prosecutors when they exonerated 15 people in one day. What happens is once you find a detective engaging in terrible tactics so that people who were not even at the crime scene are getting convicted of stuff they never did and somehow have mysteriously confessed to things that they didn't do and they didn't see and they could not have even known. When you start to realize that, that means you have to look at everything that detective did. And you have to wonder what tactics that detective used on every other person whose confession was taken. When you start to do that, you can end up where Kim Foxx ended up and where we are headed, which is once you've identified because of DNA exoneration and because of video exoneration of someone who's across town, once you have this conclusory evidence that shows the person didn't do it, and you're holding a confession that would have been impossible without a detective magically transposing to the mind of the defendant certain ideas, or at least just writing it himself. Once you see that, you have to look at everything that detective did. And it can be really alarming. Listen, we have in Philly right now, there is a homicide detective sitting in a jail cell. And he is sitting in a jail cell because he is charged with the sexual assault of several informants. These are informants he used in homicide cases, and young men, by the way, and used those informants and pressured them in ways that included things like threatening to shift blame to implicate them for homicides if they did not do what he wanted them to do, both in terms of the case and sexually. I am not making that stuff up. Look it up, Detective Phil Nordum. So once you realize that how much harm an individual homicide detective can do and how much harm a culture that validates this can do, you got a problem. Let's not put it all on the cops though. What the usual type of exoneration we see when it comes to non-disclosure of evidence helpful to the defense. And for this, you could look, for example, the case of, what's his name? Dante Patterson, I believe is his name. He's one of the first exonerations we had. Homicide detectives keep their own files of their investigation. Homicide prosecutors keep their trial files. If you got a whole bunch of statements sitting in that homicide file that say the defendant didn't do it, or I think this other person did it, and none of those files were ever given to the defense at trial, none of those statements were ever given to the defense at trial. None of those statements are contained in the homicide file when it was required that the prosecutor sit down with the homicide detective and go through everything, then you know what happened here, which is that those statements were shredded, they were crumpled up, they were concealed, they were hidden. It was a violation of constitutional rights under Brady. And we have seen that over and over and over, sometimes repeat players, the same prosecutor doing it over and over and over. I mean, the truth is, there's plenty of blame to go around when it comes to a win at all costs attitude that disregards the Constitution, doesn't care much about innocence, just wants to run up numbers for being able to clear cases. But it's a national tragedy, and we are very lucky to have someone like Patricia Cummings, who came here with a ton of experience, having run a conviction integrity unit in Texas first, who was a very experienced criminal trial lawyer for over 25 years, I think about 25 years anyway. And she's just done a bang-up job here of turning around a city that didn't know to exonerate anyone and didn't want to exonerate anyone, and getting us to the point where we have a fully staffed unit that takes this stuff very seriously and is proceeding in ways that are modern. She is at war, make no mistake, she is at war for things as simple as wanting to retest a piece of evidence, for wanting to run a DNA test. I mean, this is an office that fought defendants who wanted another DNA test done or a DNA test done. They would fight them for years to try to prevent that. We are 100% in favor of DNA testing being done because it'll show they're guilty if they're guilty. And it'll show they're not if they're not, which means we have an unsolved crime we should still be trying to solve, right? She has done an absolutely bang-up job, but she has problems with things as ridiculous as the homicide detectives don't want to give us their files. Can you imagine? It's a battle, and she is a warrior. She's doing a fabulous job. You're going to hear from her hopefully very soon. And it's also inspiring, and I hope for those of you who are drawn to this kind of work, as I know you are, Geneviéve, because you're a volunteer for Innocence work, you should do it because it'll be worth it.
Indeed. And you know, I was talking with a community member yesterday. Unfortunately, her husband has been wrongfully prosecuted, not convicted yet. He is just being held in jail. It's now been over 2 years. Of course, COVID isn't helping, but he's in LA. And she told me yesterday that it actually makes her nauseous to see folks celebrating the release of wrongfully convicted persons, because those injustices should have never happened in the first place. And it really did put that into perspective for me. And so I really do applaud the work that you all are doing in the office, not just to right the wrongs of the wrongfully convicted, but that you're also holding people accountable and making sure that through the culture changes that you're implementing and putting in place, the policies, everything that you're doing in that office, you are basically ensuring that this doesn't happen again. And so I just want to thank you for that, Larry. I think that the work that you're doing obviously is very, very important in that vein. And before we close out and before I give it over to Nikki, I do want to take some time to just talk about defunding the police and how it is connected to the DA's office. We've been hearing a lot about defunding the police. So Larry, what does defunding the police mean to you, and how does it connect to the district attorney's office?
Wonderful question. So, you know, I had 25 years of representing a lot of very idealistic demonstrators, protesters, activists, and organizers, almost always pro bono. I just am in love with the First Amendment, and I used to do that. Some of those people are prison abolitionists. I am not. I actually think that there is a much smaller number of people who need to be incarcerated, at least for a period of time, for a variety of reasons. So likewise, I think, for example, that it's ridiculous that Philadelphia is about to become the 7th largest city, but we have the 4th largest police force in the United States and a chronically high level of violence, very much like Chicago. Chicago has very, very high levels of policing, and yet it has very high levels of violence. So it is pretty clear that just having a ton of cops around does not solve your violence problem. I am in favor of disinvesting in police, divesting from police, meaning moving some money away from that to things that are far more worthwhile and that will do a much better job of healing society, preventing crime, making us safe. I think we have to do that. But I am not someone who believes that we should eliminate policing. It's an ideal I hope somebody achieves in the future. I don't think it is achievable at this time, just so you all understand where I'm coming from. I also think the language of defund, we have to be careful about that only because there are other ways to talk about it. I mean, they used to talk about divesting in South Africa during apartheid. They didn't necessarily say defund. And unfortunately, the phrase defund, if it's not explained, it can play into right-wing Donald Trump rhetoric and his corny commercials, you know, with old folks on the phone praying for police services that aren't any there because of the defunding. So I think we just have to be careful because it is so important that we do not have Donald Trump as our president moving forward. We just have to be careful to explain it if we're going to use the phrase, or to use some of these other terms like disinvest or divest. We need to shrink the footprint of correctional criminal justice. We need to shrink the footprint of policing, and we need to put that money into things that work, like heavy investment in community-based organizations over many years in anti-violence programming. It works. It reduces crime at the same time you're reducing custody. We need to put a lot of money into public education, economic opportunity, treatment, all sorts of things that actually do a much better job, dollar for dollar, of improving society, reducing crime, and making society whole. That's where it needs to go. And that really is the point, for example, of our policy of requiring our assistant district attorneys to calculate the cost of the incarceration they think they want. I want them to realize, if they're going to walk into a courtroom and say that they feel that this, homeless person should be in jail for 6 months for stealing food, I want them to explain to a judge that the person stole $12 worth of food and it's going to cost the taxpayer $30,000 to put this individual in jail for that period of time, because when you phrase it that way, it's too stupid to even think about, right? It makes them stop. I think we need to face up to these things and realize that there are limited resources in society. We can put the resources into things that work, like fabulous public schooling and economic opportunities and all sorts of summer programs for youth, things like that. Or we can just keep building more jails and more jail cells. And unfortunately, the monster we have made, this Frankenstein monster of enormous incarceration, for example, all the way across Pennsylvania, has kind of sort of gotten us back to a trade in human bodies. Because, for example, the people passing all the laws in Pennsylvania is like California. We got a couple of big liberal cities, and then we got a whole bunch of rural areas where they have a very different viewpoint, as I'm sure you're aware. Well, what happens in Pennsylvania is that you have a legislature that is dominated by the counties that are more rural, more suburban. These are counties where the prisons are. These are counties where they make money off of the prisons, but they need bodies from Pittsburgh and Philadelphia, which are two big cities, to put into those locations. It doesn't just give them money. As John Pfaff has explained in his book, Locked In, it gives them political power. It allows them to gerrymander. It gets them highway funds for people who are sitting in a jail cell so they can't drive a car. It gets them voting rights for people who are sitting in a jail cell so they can't vote. At many, many different levels, there has become, through this oversized criminal justice system, a commerce in taking bodies of people who are in the big cities, and we know in Pennsylvania exactly who those people are, and putting them in jails upstate. So yes, we need to defund police. We also need to defund everything else in the criminal justice system that is pernicious and that tears us down, by which I mean disinvest in it. Like I said, I do believe that Charles Manson should stay in jail. I do believe Ted Bundy should not be told he can go home and kill more blonde women. I believe that. I think there's a role for custody, but the role is so much smaller than we have here. I will give you one final example just to bring the point home. Germany has a not exactly perfect history in terms of its capacity to use incarceration, the power of the state to murder people, okay? Pretty bad history. But if you look at modern Germany, what you will find is they have about 1/9 as many people in jail and as we do, and they have about 1/9 as many homicides as we do. They are doing certain things there that, at least in modern times, are healthier than what we are doing here. We have to be able to look at that and say that there is a way to disinvest in jails and also to reduce crime. And if we do that, we're going to be in much better shape.
Indeed. I really do think that the conversation around defunding the police is a very important one, because this conversation allows for the community to take ownership of the conversation around public safety. And I think for a very, very long time, for far too long, we've allowed police officer associations to frame the narrative around policing and what public safety means. This conversation allows for community members to reimagine policing and reimagine how police show up in our communities. I think that it is no longer a secret that different communities are policed differently. And so for me, this conversation is an empowering one. And it really does beg the question, well, whose money is it anyway, right? When we talk about defunding the police, I think we start at a place where we're saying that it is their money that we are taking away from them. And I want to look at it in a different way. So I do appreciate your comments about that, because that term is one that will start conversations, only because it could be a very hot button conversation or topic, but also because there could be a little bit of confusion around what exactly do you mean by defunding the police? We
Right.
talked about abolishing the police, and we are absolutely sure that there is the thought that we don't need the police on one extreme. The other extreme, to me, is where we are, where our police agencies and departments, our law enforcement agencies, can have militarized equipment and weapons, and they get whatever they want. They get the budget that they ask for, and they don't have to justify it. And I love something that Professor Jody Armour speaks about, and it is that defunding the police to him is the middle ground. So it is right in between those two extremes of give them a blank check and just abolish the police altogether. It is saying, let's meet in the middle. Let us understand that there's a better way to do policing, and that we should be investing in community-based organizations like you're talking about, Larry, and schools. And so I love the conversation for that reason. And so thank you very much for having that conversation with me. And thank you again so much for just being here in general. I think it is so important. This conversation is to the conversation about reimagining policing, prosecution, and punishment. You have shown us the real power of the district attorney and what can be done through that office, helping to right wrongs, having accountability, and ensuring that justice is really what is being sought in our courtrooms. So now at this time, I'm going to hand it back over to Nikki Hurst-Cook, unless you have something else to say, Larry, before we get to questions from our attendees.
Just that it's really wonderful to talk to you, and I'm so glad you mentioned Jody Armour. Just like I'm a big fan of yours, I'm a huge fan of Jody Armour's. So if there are questions, let's go.
Yes, we have some great questions from the audience. The first one is, can you talk about the influence of law enforcement unions generally, and what do you think about DAs taking contributions from police unions?
That is a wonderful question, and I think some of the best writing I've ever read on this topic was done by actually a poet whose last name is Ewing, E-W-I-N-G. She had a Vanity Fair article about a month ago, I think. Couple of quick points. First of all, the reason that most of them are not called unions, they're called fraternal organizations. It's the Fraternal Order of Police in Philly, or the Benevolent Association, is because they were used to put down unions. And they were used to put down unions for a long time. Sometimes, if you look historically, by killing people, and other times by arresting them for simply trying to get together and do things like create weekends in public schools for children, all right? So that is one of the anomalous and curious things. They almost always have these sexist names as well. It's almost always fraternal or a brotherhood. What they are telling you is their history, and to some extent their mindset, and the extent to which they are not, or at least were not when they were first formed, what we would hope they would be. They have stayed that way. Unfortunately, most of them are still a voice of the past. They're not a voice of the future. One of the things we see in Philly is that most of the membership of our Fraternal Order of Police is retired, most of it. So when they go to vote on the leadership, an overwhelmingly Republican, conservative, and white male contingent of retired people who don't even live in the city are deciding who should be the head of that bargaining unit for a much smaller active police department that is much more female, much more black and brown. It's kind of a crazy town. So, we are an 80% Democratic city, but our local police union, the Fraternal Order of Police, as they call themselves, is going to come out and endorse Donald Trump, causing, by the way, an outrage among the African American Officers Association, which is not the bargaining unit, it's not a union, who then do their own press conference about how disgusted they are that the union is backing the white supremacists and they endorse Hillary Clinton. This happened in a prior election cycle. So you're hearing from the voice of the past, and they have had so much sway and control that they will tell you not even to believe your eyes. You watch a man who's knocked down somewhere up in New York State, 70 70-something-year-old man is obviously pushed down, falls on the back of his head, cracks his skull, bleeds all over the pavement. Head of the union comes out and says he slipped. What are we talking about? What do you mean he slipped? And everybody and anybody who sees that sees the officer push him down, causing him to break his head open. But they have been so powerful, and they have been so able to do what fascism does best, which is to change the meaning of language and convince you that reality is not reality, that they're actually willing to say that. They're actually willing to say that kind of crazy town. They have too much power. I refused to accept the endorsement under their current leadership when I ran last time. It only helped me. Okay, it only helped me. I have refused to accept any contributions from them this time, as have many other candidates. It will only help them. We are not living in 1954. The leadership of these police unions is, but we are not. And therefore, in general, in large urban areas, the people don't want to know that the DA is in bed with cops. DAs have to be a check on everybody's behavior. They have to apply the law equally to everyone. They don't want to know that the DA has a pocket full of money from people he or she is responsible for holding accountable. It's a real problem, and I am a huge backer of labor. I have tremendous amount of labor support, but this is a special kind of labor. They get to shoot you, they get to arrest you, they get to stick you in a jail cell, okay? There is a level of accountability that has to go with that. There's a level of public trust that's involved in their job, and they simply cannot be allowed to run completely unaccountable as they have been in so many jurisdictions.
Nikki, Larry has pretty much said it all, so I just have to say ditto and amen. But I wanted to add that we have to be cognizant that language is powerful and it matters. And so even when talking about defunding the police, I'm always cognizant that I will not ever refer to them as police unions. They are POAs, where we are here in California. Certainly we have the Fraternal Order of Police in Philadelphia that is very, very strong and very vocal about the things that we all care about and pushing against them. So I think that language matters. Also, I will say that we have to understand what it looks like. And from a practical perspective, during my race, it was very off-putting and it was very concerning for me to see my opponent's signage say law enforcement's choice. Because when we're talking about hundreds of police shootings that led to the deaths of lots of community members, and that the district attorney's office has a history of not prosecuting these officers, that does not send a good message to the community that the district attorney is actually acting in the name of the people or for the people, but that she would be acting in the interest of law enforcement because that's where her allegiance is. And so we're seeing candidates, as Larry talked about, like Eliza Orleans, who's running for Manhattan District Attorney, Corey Briggs, who's running for City Attorney here in San Diego, George Gascon running for DA in LA, saying, I do not want their money, I will not accept it, I will not accept their endorsements. And we have to have more pledges like that from folks who want to be the district attorneys or the state attorneys for their respective jurisdictions. Because for me, that builds trust between the people and the district attorney's office.
Thank you both. The next question is, as the number of exonerations continues to rise, we have seen the number of recanting witnesses in innocence cases being charged themselves with perjury, which of course can have a chilling effect on future witnesses' willingness to come forward. Do you have a policy in your office on charging recanting witnesses with perjury?
I'm going to try to be quick because I think I'm talking too much. Let me see. We don't have a specific policy. In general, in recantation cases with civilian witnesses, what we see is they come in later and they say, I was pushed, I was pressured, I was coerced, I was threatened. And so I said what it was that the detective or the prosecutor or both wanted me to say. To me, that is not a situation where law enforcement is pushing you to break the law. That is necessarily appropriate for prosecution. I can't imagine a world where in a particular case it's appropriate, but but not a situation where witnesses who would have told the truth in the first place were pushed and prodded and forced to say something that was untrue.
This next question is for both of you. Both of you ran to be DA as candidates from outside the DA's office. What, if anything, surprised you when you were running as an outsider, and what obstacles did you face? Additionally, what was your strategy for addressing those obstacles?
You go, Genevieve.
Well, not surprising to me, there was a very big campaign to paint me as the outsider, where they created this othering. And I thought that that was very important to not run away from during the campaign, because it didn't make sense to me. I had worked for years and years alongside of district attorneys to get what I thought was justice for clients. And that includes sitting in rooms and having meetings and giving mitigation evidence. And all of a sudden it became a them versus us type of thing. And for me, being a public defender only strengthened my abilities to be a great district attorney, because I believed that that would make me better in that position and making decisions that were human-centered. And because I wasn't coming from inside of an office that I believe really does have a culture of win at all costs that Larry spoke about. So it wasn't surprising to me, but it wasn't less hurtful to see colleagues and folks that I had worked with for many years do that othering. And that was a very big tactic, but you know, again, it was something that I expected, but probably not at that level. But that was a very, very big part of discrediting me and my ability to lead a district attorney's office.
Let me just, I think that's a truly excellent point. My mother, who actually was a tent evangelist a very long time ago, used to say, you know, you're doing something right when you angry up the devil. Well, if the head of the Fraternal Order of the Police, whose reputation is well known, hates me, that helps. If people who are insiders in a system the public views as being unfair, racist, illegitimate, and too carceral, if those people say you're an outsider, that actually helps. I mean, obviously, politics is all very, very local. But honestly, I kind of hope I remain an outsider. And there are some of these terms and these accusations that are thrown at us are nothing different than what was being thrown at Dr. King. You're an outside agitator. Was he really? Man who's, with a few others leading a national movement is outside when he's in the United States. He's an agitator when he's entirely peaceful. This is what they do. This is what they do. So long as you're able to stick to your guns and say, yes, I am outside what you're doing. You should be ashamed of what you're doing. That, I think, can actually, from the political perspective, play very well in your favor.
Thank you. We are actually right at the end of our time, so we have about a minute left. If you each have closing words for our audience about going forward, for people to take this knowledge with them, what they can do and how they can be engaged with these issues in their community.
I'm a very big call to action person. I will say that we have a lot of propositions on our ballot in California, at least, that deal with criminal justice reforms. There are a lot of attempts at rolling back some of the criminal justice reforms that we voted as a people for back in 2014 and 2016. I will say, please educate yourselves about propositions 20 and 25, propositions like 16, 17, and 18. We have a chance to restore voting rights to parolees. I think that is very important to this conversation about reimagining punishment. Why should I lose my voting rights because I am convicted? And we have to remember that parolees have served their time. I mean, there's a bigger conversation we can have about whether you should lose your voting rights at all being in county jail, pre-trial, pre-conviction. But certainly, those folks who are back in our community, we need to give them the opportunity and the full advantage of being included in our community and so that they can vote and have their voices heard. So I would say that going forward.
I would just say this, criminal justice reform, in my opinion, is the civil rights movement of our time. It really is. These things are a good 30-year cycle. We're probably 10 years in. So a lot of people who are listening to this call who are much younger than me are the ones who are going to complete this mission. I think where decarceration has to start is with decarcerating our minds. The people who've been controlling the system for a long time want us to believe we cannot change it. Well, you can. No matter how unlikely, Geneviéve went up there and tried. I went up there and tried. A lot of other people are trying. Do not let people in power tell you they are there because they're so smart and they're so powerful and they got so much money. They're mostly there because they convinced you not to try. So break your brain out of its jail cell and go after them. And what you will see is people are thinking like you're thinking more than the people in power suspect. Thank you very much.
Great. Thank you so much. This was such a informative and exciting panel. And I also want to thank the audience for joining us. And just as a reminder, we hope that you will all join us next Friday at 11 a.m. for a panel discussion about faulty forensic science and a conversation with Amanda Knox and Jared Adams. So we will see you next week. And thank you again to both of our panelists. Thank you, Larry Krasner, and thank you, Geneviéve Jones-Wright.
Thank you. Bye, Geneviéve.
Bye, Larry. Talk to you soon.